this is Attorney Doug Jones. Welcome to Elder Law in 5 Minutes. Well, today I'm going to be talking about today's newsletter, which is Trust Planning, Avoiding Probate with a Revocable Living Trust. And by the way, if you don't get our newsletter, you can get it for free by going to elp.legal and just signing up. And you'll get it in your inbox every week. But let's break this apart a little bit. Revocable living trust. The first word, revocable, this means that, it's your trust. You can revoke it at any time. I don't know why a person would pay a lawyer to set one up and then revoke it, but you can. You can revoke it. You are in full control of it. Living just means it was set up and it's operational during your lifetime. Living, sometimes you hear the term inter vivos, which means during your lifetime, as opposed to testamentary. And a trust can be a testamentary trust. In other words, it's not operational now, but it's the words of the trust are in the body of your will. And to make that work, you would have to probate the will after you die, your will, so that assets can go into the testamentary trust and be controlled by the trust. The only problem with that, a lot of times people want to avoid a probate. That's the very reason they set up a living trust, or that's one of the big reasons, is so they can avoid the probate process. But you can set up a testamentary trust, which is a trust and a will. Now, the different players, so to speak, in a revocable living trust are the settlor or trustor. You hear it called both, and that's the owner of the trust. It's your trust. We use the analogy of a box sometimes, but it's your trust. You own the trust. It's yours, and you control it. You're the owner, or the settlor, or the trustee, or trustor. Owner, settlor, trustor. The trustee is a person that manages the trust, and you are the trustee. You can open it up. You can put assets in a trust at any time. You can take the assets out at any time. You're in full control of it while you're living. And then you would have a successor trustee that would take over after you die. And so your successor trustee may be one of your kids or two. Can you have two kids as co-trustees? You can. Now, whether you would want to or not, or whether that's even a good ideal or not, I don't know. They're your kids, I mean, do they work well together? Would it be a good idea to have two of them? Sometimes it's a good check and balance. Sometimes in a second marriage situation, I've seen people want one of the kids from one side and one of the kids from the other side serving together as co-trustee. That may be a good ideal. Again, you have to ask, can they work well together? What if they live 2,000 miles apart? Is that going to be a problem? It's not as big an issue anymore, with overnight mail delivery and with faxes and email and Skype and Zoom and Slack and all of this stuff where they can communicate instantly. It's not as big of a deal anymore. What if you're married? Can a husband and wife have a trust together? Yes, you can have a joint married trust, at least in Arkansas. You can have a joint married trust, where the two spouses work together to own the assets together in the trust, or they can even schedule them separately if they want to do that. And they can be co-trustees of the trust, and usually are. After one of them died, the other spouse can continue to be the trustee, and then of course they can name whoever they want to serve as successor after both spouses die. How about distribution? Well, you can do it, have specific distributions or residual. A specific distribution might be, I want to leave the farm to Bobby, the rent house to Sally, our home to Johnny, and then everything else, residual, is split third. Or you can do it any way you want to. Does the residual have to be split equally? No. If you want to leave, if you had 3 kids, if you wanted to leave one of them 50% and the other two 25% each, or any number you want, just so it adds up to 100%. What if one of the kids die? Well, if they die before you do, the ball's still in your court, so you can say, if Johnny dies before I do, his share goes equally to his kids, or whatever you want to happen. You can just say, I want his share to lapse, meaning I just want it to go equally to the other 2 kids. So you have a lot of flexibility in setting up a revocable living trust. It can be any way you want. The key is to meet with your attorney, and there's a lot of things to think about and to make sure it's set up in the way that's best for your family. If you live in Arkansas and we can help, give us a call, 501-843-9014, or go to our website at arcelderlaw.com for more information. If you're watching this YouTube video, and you probably are, click subscribe if you hadn't already. And if you liked it, give us a thumbs up and leave a comment. We'd love to hear what you have to think and have to say in your experiences and your planning process. Thanks for watching and have a great day.